Welcome to this edition of Real World Business Law, where we discuss real-world business issues impacting companies and executives. I'm Declan Leonard. I'm managing partner here at Berenzweig Leonard, and I also head up the firm's employment law practice.
And I'm Aleksey, and I'm an associate here at the firm.
And we are here in the BLC Digital Strategy Studios here in Tyson's once again for one of these video podcasts. Aleksey, great to be here with you. We've got a good topic today, but before we jump into that, I need to know, how happy are you that Michigan's in the Final Four for football playoffs?
You know, I think it might have been one of the happiest days of my life. Go blue.
Don't be too confident there. The mini mighty TCU might surprise a lot of people. Well, anyways, let's jump into it. So today we're going to be talking about Virginia's Consumer Data Protection Act.
Yes.
And I have to just tell you, to be honest, when I hear about sometimes data protection, data privacy, my eyes gloss over because I'm just like, what are we even talking about? So give us a high level of what are we talking about when we talk about data protection, data privacy?
The Act defines personal data as information that is linkable or reasonably linkable to an identifiable person. So it could be your name, your address, and then it goes into a subset category of sensitive data, such as social security number, health data, religion, things like that. And so the purpose of this act is to ensure that businesses are taking appropriate security measures to protect that information, given the prevalence of security threats, breaches, and things like that have been happening.
Okay, so what we're talking about here is it's very important maybe that we should identify exactly what kind of data we're talking about. Data is such a broad word.
Right.
We're not talking about business-to-business data. We're not talking about, do you say data or data?
I think it's like tomato.
Sorry, I might say it both ways, even on this quick broadcast. But we're not talking about business to business.
No.
We're not talking about employment information, right?
So that's one of the differences between Virginia's Data Privacy Act and, say, California's.
Yeah.
Under Virginia's Act, employment context or data in the employment context and business-to-business data is excluded.
Okay.
Consumers are defined as, Virginia residents acting in an individual context. Solely commercial context is excluded under the Act.
Okay, so if a company has a Virginia resident who's a consumer, like I'm thinking this applies a lot to like retail companies. Who does it apply to?
It applies to, well, actually, let's start with the way that the statute says. The Act applies to entities that conduct business in Virginia or produce products or services in Virginia that target Virginia residents and that either A, control or process personal data of at least 100,000 consumers during the calendar year, or control or process data of at least 25,000 consumers and derive more than 50% of gross revenue from the sale of personal data. So it could apply to retailers. It could apply to, any company that is handling a lot of personal data, collecting it, selling it, using it, things along those, sharing it with third parties.
Whenever I see these definitions, first off, that was extremely technical. I need a sip of my coffee here. But that
waking you up on Wednesday.
Exactly. Whenever I hear those definitions, I tend to think, oh, that doesn't apply to X, Y, and Z. That's a pretty limited subset. I look at that definition and I think, that's kind of misleading. Like I think of our law firm here, we handle payments from clients and, we handle, individual consumer information. So, we probably don't hit the threshold of what the Virginia law is looking to target. But I think companies really have to look at that definition very closely and say, you know what, I'm not, a retail store and I'm not doing all of these different transactions on a daily basis like a 7-Eleven or a Wawa, so why do I really care about this? But it actually could apply to a lot more companies, isn't that right?
And that's an important point to bring up, is because I think the misconception here is that when you hear of a data privacy law, if you're not in tech or if you're not in the business of selling or sharing that information, you think it doesn't apply to you, and then it's a rude awakening when the Virginia Attorney General comes knocking on your door next year. So it's important to realize that controlling and processing are such broad terms, and collecting that data, you can be subject to these requirements. And in terms of, employment records, that's actually one of the exclusions under the Act.
Yes.
So here, again, that data, if it's in the employment context, employment records, other, health information that's protected under HIPAA, those kinds of things, they're excluded under the Virginia Act. But
Okay.
it is important for businesses to look at it and think, does this apply to me?
Yeah, and you mentioned California. California was sort of the leader in coming out with a data protection and privacy law. Virginia is now following suit. Other states are doing so too. So what you're going to have is, it's not just that you're a Virginia-based business. I mean, this law applies to businesses that target Virginia consumers. So it's
Yes.
not just, well, I'm not located here in the boundaries of Virginia, so I'm going to move on and go to the next law. It could very well apply. In fact, talk about there's a patchwork of state laws that are coming into play. It makes it tough for businesses who operate in multi jurisdictions. Why doesn't the federal government just step in and do sort of an overriding one and put some clarity into this process?
The $1 million question. They've been trying. This year it got shot down, and it hasn't been able to move forward since then, I think around September. And the problem there is that they want to lay a baseline of, privacy protections, data protection requirements, but every state's different. Businesses are different. Obviously, California's is very strict, whereas Virginia's is more succinct and less far-reaching. And so I think that there's just going to be a lot of obstacles along the way to agreeing on a federal standard.
Okay, so under this new Virginia law, what are they requiring qualified businesses to do with respect to it? Like, what do they have to do?
So, the overall purpose is that they want to limit the collection of personal data, and they want to limit the processing so that you're only collecting and using that information for those limited purposes. And that turns into, you need to provide certain privacy notices to these consumers and tell them, of their rights under the Act, such as like their right to know that their information is being collected and processed, and for what purpose, to inform them of their right to access the information, to delete, correct, things along those lines. Those are the consumer rights aspects of the Act.
So those are the notices. I get those sometimes in the mail. I obviously not pursuant to the Virginia law, but you get those sometimes. Credit card companies, you open it up and you're like thinking it's your bill, and it's really just a notice, and it's a lot of words, and I usually just throw it away right away. But I guess somebody took a lot of care to put that together. I should read that from now on.
Well, yeah, and they're just trying to, protect themselves from the Virginia Attorney General.
So is this a paper-pushing statute, do you think, or do you think it's got some substantive teeth to protect consumers?
I think it does have some teeth. It remains to be seen how it actually plays out, but there are measures that employers and not employers, businesses should start taking now to prepare to comply with this, because not only is it providing those privacy notices, but you also have to conduct impact assessments. You have to make sure that you have a system set up for when consumers request that information, and you also have to review your contracts and your policies to make sure that if you are using a third-party service provider, that they're also protecting that information in accordance with the Act.
Yeah, so when I hear all this, and I run a business here, we work with so many businesses as part of our law firm, I think of that as just a time suck and maybe even a money suck. I mean, that's just, so who in the company do you see, like, what role in the company do you see administering this? Because, you could see it really taking on a life of its own and being very time consuming and taking a lot of money to comply. So who would you see doing that role?
It's no lie that it's going to be an upfront cost, but it's a reality that all businesses are going to have to start considering going forward. And one of the big trends is companies are now dedicating an entire team or identified personnel to handle data protection, whether it be a data protection officer, a team, but it is a trend going forward that there's going to be a separate team to handle these kinds of matters. So
it's not like you can just delegate this or slough it off to one particular person, because it sounds like the way this works with data protection and the risks that are involved, it sort of permeates the whole process. So it's not just, hey, we need to make sure that our employees are handling this sensitive information the right way. But you also, most businesses have a ton of vendors. And so, you've got, your sales folks who are negotiating these contracts. They better be putting in data protection provisions within their contracts to their third-party vendors. I mean, that's really what it is, isn't it?
Yeah, and that's one of the main obligations of covered entities under the Virginia Act is that you do have to, look at your relationships and consider whether it's required or not. And more often than not, it's going to be required, but you need to make sure that those security measures are being passed down through the chain.
Got it. And I'm thinking about a scenario where your company may not even be covered under the statute, but the provisions are being imposed upon you because you're a vendor of a company that otherwise qualifies. And so, I'm thinking Target. I always go back to this. Target had the big breach.
Yes.
Credit card information of its consumers was stolen, and everyone just thought, oh my gosh, Target. How did that happen? And I think the true story is that some hackers were able to get in through the HVAC, the air conditioning and heater vendor for Target.
Yes.
And so you don't even think, you're trying to button up everything in your own company, and you got to, now there's such an interrelation between businesses that you've got to be looking outside as well as inside.
Exactly, and it's that saying that you're only as strong as your weakest link. When everything is as connected as it is, and there's as many entities involved in the supply chain, they're going to look for the easiest way in. And so that's why they want to make sure, and when I say they, I mean, Virginia legislatures and other states, they are looking at how they can protect the entire chain. And that's why those agreements are being required now.
Got it. So what's the downside to a company? If something goes wrong, they don't comply, can these consumers just start filing class actions in Virginia?
No. So under the Virginia Act, there's no private right of action. And the enforcement authority is with the Virginia Attorney General. And there is a cure day period. So if you got a notice that you were non-compliant with the act, you have 30 days to cure it. But going forward, if you remain non-compliant, there's a $7,500 penalty.
Got it. Okay, so there's some real monetary downside there. So it seems like it's worth taking this seriously. As we finish and wrap this up, what are some things, sort of some concrete things that companies can be doing, between now and this goes into effect the first of the year, 2023, right?
Yes. Yep.
Okay.
January 1st.
So what are some things that they can be doing even now in December as you lead into the next year?
I would say that it's important to start with data mapping and data inventorying, which is, just looking at what information you collect, how you store it, things along those lines, the current data privacy measures that you already have in place. I would also recommend reviewing policies and contracts like we talked about to make sure that if those, security measures are not in there currently, that you put them in, and, just dedicating resources to complying with this act.
And you hope that companies, probably already have this on their radar anyways. I mean, like we said, Virginia is not the first state to do this. Many of our clients operate in multiple states, some of which may have already enacted their own data privacy. California, exactly. And it is an issue. Protection of sensitive information, consumer information, is really front and center. In fact, about a half an hour before we walked into the studio here, I got a notification, Washington Post notification, that Apple is going to allow full encryption on its iCloud, service, going forward. So they're just acknowledging that, this is a problem that's not going away, and that, these efforts by these states are not going to solve the problem. They'll help it a little bit, but it's going to be sort of a whole cloth approach to it in order to try to keep the hackers out.
And it certainly is a trend that's not going away, and it's here to stay. And I think that's why it's important for businesses to look at making these investments to have that competitive advantage going forward, because you don't want to be the business who doesn't comply with state law, federal law one day, maybe in terms of data protection. And I think with the increasing technology and threat of breaches and whatnot, you want to be the business where people feel like their information is safe.
100%. Yeah. Well, listen, great discussion. It's an important topic. Any final final words of encouragement for Michigan?
Go blue. And I think it's not Texas, but like frogs down or something like that.
Wait, what is it? Oh, now
they're horned frogs, and so like at Kansas State they were doing this to
got
get
it.
the horned
Okay.
frogs down.
Yeah.
Go blue.
All right, you heard it here first. All right, thank you all for joining us on this edition of Real World Business Law.
Thank you.